Okay, let's continue.
I just have a couple of additional questions.
Great. Thank you.
Mr. Sullivan, I just want to clarify. If you could turn to page 12, line 11 of your direct testimony. Am I correct that in August 2018, Duke Energy's outlook as a result of the TCJA was one of the first, if not the first, utility to have its credit opinion restored to stable?
You are correct.
So that leads me to a question then for Mr. Hebert.
That was following Duke Energy's $2 billion largest common equity offering to respond to the negative credit impact of the tax reform.
Mr. Hebert, am I correct when I look at your direct testimony and your testimony in this proceeding to understand that you go through your various modelings, the DCF, the CAPM, et cetera, and those produce a various range of results, and then from there you identify a couple of additional factors that ultimately prompt you to select a range at the higher end of your modeling's results?
In this case, yes, as a general proposition, I will run the models. I will look at the range of results. I then will consider other factors, often qualitative, to determine where I think the cost of equity falls within the range.
Can you turn to page 77 of your direct testimony?
Yes, I'm there.
Starting at line 23, and I'll put it up. Am I correct that one of the factors, and I'll see if I can fit both pages here. Am I correct that one of the factors, I think you indicate on line 6 of page 79, that you focus on the upper end of the range of analytical results, and that's in part because in June of 2018, Moody's changed its outlook on the U.S. regulated industry as a result of the TCJA?
Well, you did point out that there are other reasons, but yes, that was one of the three.
But for purposes of Duke Energy Progress, that negative rating by Moody's is inapplicable since in August, Moody's changed Duke to stable.
Well, I think Mr. Sullivan answered that it changed to stable in part because of the company's response, but that does not affect the other factors. It does not affect the fact that other industry sectors were able to benefit from the Tax Act in the way utilities could not. It does not affect the fact that the whole intent of the Act was to generate additional growth, which would increase expectations. So I agree that it would affect that one factor, but not the other two.
Mr. Hebert, Mr. Sullivan, thank you guys for your time. I don't think I have any other questions.
Thank you.
Thank you.
Thank you. You want to move those four in?
I do, in fact, want to.
Okay, we'll enter those. They're 46, 47, 48, and 49. We'll enter those as those hearing exhibits. Okay, NAACP, SCCCL, and Upstate Forever. Sierra Club. Energy Users. Nucor. ORS. Commissioners. Any redirect? Whoops, hang on. I jumped the gun. I got excited. Commissioner Williams.
Thank you, Mr. Chairman. A question for Mr. Sullivan. Could you share your thought with me on how the company continues to maintain strong credit metrics while preserving customers' need for lower rates?
Sure. I think one of the things that is most in our control is managing cost. We are undertaking many initiatives to try to manage cost such that the cost that we are seeking to recover is the lowest we can operate by. I think credit quality and good credit quality and reasonable consumer prices can coexist. It's not one versus the other necessarily, but rather if we're managing our costs as carefully as we can and managing the capital structure and our capital investments in a way that result in a balanced capital structure, I believe we can try to accomplish both.
Could you give me an example of cost management?
Absolutely. Well, I guess since one of my primary responsibilities is to raise capital in the most cost-effective way, I could describe to you how we go about keeping capital costs as low as possible. In the past couple of years since we've last been here in front of a rate case, the overall cost of debt for Duke Energy Progress is, as we present in this case today, 4.16%. 2.5 years ago, at our last DEP South Carolina case, it was 4.17%. So we're talking about 1/100th of 1% has been the change in the cost of debt capital that we've tried to manage. Now, behind the scenes with all of that has been increased volatility. The federal funds rate has gone from, I believe it was 75 basis points at that time, the upper end of the 25 basis point Fed's fund rate range, to today 2.5%. So there was a good bit of discussion earlier this morning about how interest rates have decreased, and I would tend to agree with that as it relates to the time frame between, say, November of last year and early March of this year. But for the most part, Duke Energy Progress raises capital for long-term investments by looking to the long-term capital markets. And we issue bonds with 5, 10, and 30-year maturities, and the cost of that capital hasn't really fluctuated as much as others have indicated so. So I'd say while the company is undertaking a large capital investment program to make investments that we feel provides benefits to the customers by keeping our borrowing rates virtually constant during a period of volatility and, in fact, rising longer-term interest rates, we feel good about that.
Other questions? Commissioner Urban.
Thank you, Mr. Chairman. Mr. Havert, would you agree that the average ROE authorized by state regulatory agencies for electric utilities has fallen from about 10.32% in 2007 to 9.56% in 2018?
Commissioner, I'm not sure where you're getting those numbers. If your question broadly is, have authorized returns fallen since 2007, I would agree with that. If the question is, have they fallen since 2016, I would not agree with that.
Why do you not employ a CE analysis in arriving at your opinion?
It's a good question, and I will say that it is an approach that we've begun using in cases now because, in large measure, it is one of the four methods that the FERC, the Federal Energy Regulatory Commission, now has focused on. Where I differ from Mr. Parcell is the way he applies the model. In his approach, he ties the earned return on common equity to market-to-book ratios. We have a disagreement about that. In my view, there are many factors that affect market-to-book ratios beyond the return on equity. It's one, but only one. Secondly, to draw the conclusion that one is related to the other, you have to rely not only solely on the constant growth discounted cash flow model, but all the assumptions that underlie it. So we disagree as to how you should look at comparable earnings, but as to the approach itself, I do think it's an approach that is not unreasonable. And I think if you were to look at Mr. Parcell's data without considering the relationship to market-to-book ratios, that would suggest a return in the 10 to 11% range. That's simply the average expected return on common equity in the future for the proxy companies.
According to his analysis, it was 9.5%.
His 9.5%, I think, is based on his view as to the relationship between, again, the earned return on common equity and market-to-book ratios. If you'll just bear with me 1 second. So I believe it's his Schedule 11, where if we look at the expected return on average common equity for the projected period 2021 to 2023, it ranges from 10.7% to 11% mean and median for his proxy group and 10.5% for my proxy group. So in that range of, say, 10.5 to 11%.
Thank you. Those are all the questions I have.
Thank you. Any other questions, commissioners? Any redirect?
The first thing, Mr. Chairman, Ms. Wheat reminded me or pointed out to me that I had misidentified Mr. Sullivan's exhibits when I introduced them. I identified them as exhibits to his direct testimony. They were actually exhibits to his revised rebuttal testimony. So if I could correct the record in that fashion, please.
And those were exhibit number 45?
So Sullivan exhibits 1 through 4?
Yeah, 1 through 4, so they should be the exhibits to his
rebuttal.
Revised rebuttal. Exhibits to his revised rebuttal testimony. Okay, we'll make that note. And
thank you, Mr. Chairman, and thank you, Ms. Wheat. Mr. Sullivan, you are answering questions from Commissioner Williams about whether you agree that there was tension between the strong credit rating of the company and value for customers. You recall that? Yes. Is there a direct relationship? Is it good for customers if the company has a strong credit rating in a direct way?
Yes, it is.
How is that? Explain that, please, sir.
The rate in which the rate at which we can borrow is lower the stronger our credit ratings are.
And that makes for a lower cost of capital? Is that right? And which translates, as we see in this proceeding, into potentially lower rates, correct?
Correct.
Thank you. Mr. Havert, for comparison purposes, do you happen to be aware of the expected return on common equity in 2019 for Walmart?
Yes, I am.
And what is that number, sir?
Well, if we look to the same data source that Mr. Parcell has in his exhibit, which is Value Line, I believe the expected return on common equity for Walmart is 21%.
Is that the period of time 2021 through 2023? 21%?
Correct. Yes.
Okay. Thank you, sir. No further questions.
Thank you. Okay. Gentlemen, thank you for your testimony. I almost forgot you. I was just moving right over you. We appreciate you being here. You may step down and be excused.
Thank you.
Thank you.
Okay.
That's the last of the company's witnesses, and so we're, I think, ready to move on to the rest of the slate of witnesses.
Thank you. Okay, I believe it's time for Ms. Grunman, if you will call your witness.
Walmart calls Steve Chris. Good afternoon, Mr. Chris.
Good afternoon.
Would you please state your full name and current position?
My name is Steve W. Chris, C-H-R-I-S-S. I am Director, Energy Services for Walmart Incorporated.
And Mr. Chris, did you cause to be filed in this docket a document entitled The Direct Testimony and Exhibits of Steve W. Chris on behalf of Walmart, Inc., consisting of 23 pages of typed question and answers and 5 exhibits entitled SWC 1 through SWC 5?
Yes.
And was that direct testimony prepared by you or under your direction?
Yes.
Do you have any changes or corrections to that testimony?
No.
If you were asked the same questions, would your answers be the same?
Yes.
Mr. Chairman, I'd ask that the direct testimony and exhibits of Steve Chris be read into the record as if given orally from the stand and admitted into the record.
Mr. Chris's pre-filed direct testimony will be entered into the record as though given orally from the stand, and his exhibits, is it DWC 1 through 5, will be entered as exhibit number 50.
It is SWC.
Oh, SWC. Well, that makes a whole lot of sense.
Mr. Chris, could you please state for the commission a summary of your relevant background?
Sure. I have been in the regulatory world for since 2003. I was on the commission staff in Oregon. Prior to that, I did regulatory work as part of a consulting firm in Houston for a couple of years out of grad school. So my role at Walmart, I'm responsible for our regulatory interventions as well as legislative work. And so I've testified in, as of last Friday, 199 proceedings in 40 states. So have a bit of breadth in terms of how different states work and sort of how the industry goes about its business around the country.
Mr. Chris, could you please summarize for the commission your recommendations?
Sure. So to summarize the recommendations to the commission, our first recommendation is that the commission should closely examine the company's proposed increase to the revenue requirement and ROE, especially in light of the impact on customers associated with granting such increases, the company's proposed use of risk-reducing rate-making structures, such as the proposed forward-looking grid improvement plan rider, and we note that its involvement in the case has been modified somewhat, and then recent rate case ROEs approved by other commissions nationwide. At the company's proposed revenue requirement, Walmart does not oppose the company's proposed revenue allocation. If the commission does determine that the appropriate revenue requirement is less than that proposed by the company, the commission should allocate the amount of the revenue requirement reduction to those rate classes that are subsidizing other rate classes while ensuring that no subsidizing class moves to a subsidized position. To accomplish this, Walmart proposes that the commission start with the allocation proposed by the company and apply 50% of the overall revenue reduction on an equal percentage basis to only the subsidizing rate classes. The remaining 50% of the reduction should be allocated to all rate classes on an equal percentage basis. Additionally, Walmart does not oppose the company's rate design for SGS TOU or the methodology used to derive the rates. And then we have a couple recommendations around the GIP itself that it should be rejected as proposed. If it were to be approved, the Commission should incorporate all related changes in cost and revenue in the determination of the revenue requirement for the rider, including direct expected benefits associated with each project. And then if the Commission were to approve the GIP rider, it should order a change to the proposed rate design to collect non-customer costs through demand-based charge for customers that are billed on a demand-metered rate.
And Mr. Chris, has Walmart proposed a return on equity in these proceedings?
We have not.
Can you explain to the Commission precisely what information Walmart is providing to the Commission in these proceedings with respect to ROE?
Sure. So with respect to ROE, we're providing really a look at the national trends. Again, we participate in a lot of cases across the country and are able to see what the commissions are approving, as well as some of the process behind that. So it's really, I think it was discussed earlier with Mr. Hebert, it's about finding a benchmark so that as you go through your deliberations, you can see what other commissions are doing and have those numbers available.
Mr. Chris is available for cross-examination.
Thank you. Okay, let's see. Ms. Ferguson. Sierra Club, Mr. Gile. Energy users. Mr. Elliott.
Mr. Chris, I appreciate your being here. You filed testimony in many proceedings, and on many occasions they're stipulated into the record, so thanks for joining us. I do want to ask just very narrowly about your testimony concerning ROEs nationally. And I draw your attention to page 11 of your testimony, and I'm looking at lines, it's hard for me to be precise, I'm looking at the answer really on the page in the highlighted language. And I ask you, sir, if I were to read this language for you to confirm that I'm reading it correctly. In the group reported by SNL Financial, the average ROE for vertically integrated utilities authorized from 2016 through the present is 9.76%, correct?
That's correct.
You go on further to testify, overall, the average annual authorized ROE has been trending downward. The average ROE authorized for vertically integrated utilities in 2016 was 9.77%. In 2017, it was 9.8%. And since the beginning of 2018, it has averaged 9.69%. Have I characterized your testimony correctly?
That's correct.
And do you understand, sir, that all of the authorized ROEs for at least SCE&G, Duke Energy Carolinas, and Duke Energy Progress, all are higher than the national average?
My understanding is that the ROEs approved for those utilities have been generally higher than the national average.
And I would ask you, sir, given you've testified in 190 proceedings and I think in 40 states and are very knowledgeable about these matters, is there something about Duke and Progress and SCE&G that's riskier than the utilities in the other 49 states?
I would say generally, the general answer would be no. However, SCE&G does have its own set of circumstances that are unique to its business.
Well, and so as you're aware, the Commission approved a 9.9% ROE for SCE&G, so that higher ROE might be more appropriate in the case of SCE&G, correct?
Mr. Chris was very clear that he's not an ROE expert. He's just reporting on numbers that are out there. Mr. Elliott is trying now to, through his friendly cross, is sort of converting him into an expert to start offering opinions about relative risk, and that would be inappropriate and beyond this witness's qualifications.
Mr. Chairman, I'm not asking for an opinion as to what he thinks the ROE is. However, it is abundantly clear from this record that he's very knowledgeable about such matters and is in a position to testify as to the relative strengths and weaknesses of the IOUs in this state and across the United States.
Okay. We're going to overrule the objection to the extent of we probably are as far along on that line as we need to be.
Perfect timing, Mr. Chairman. Thank you. And so I think that the question was put and answered that these utilities are not any more risky than other utilities across the country, correct?
That's my recollection of my answer.
Yes, sir. Now, as I understand, Walmart's everywhere, and so Walmart has a presence in the Progress territory here in South Carolina, correct?
That's correct.
And so I would ask you, based on your breadth and depth of experience, if there's something about the customers in the Progress service territory that would justify requiring them to pay more than the national average as a result of this rate case.
Not that I know of, and I'd also like to point out, I think, obviously there are a number of factors that go into the final approved rates. ROE is just one of those factors, but when we look at our cost for Progress in South Carolina versus North Carolina, I would note that we pay about 1.1 cents per kilowatt hour more for our South Carolina facilities than we do for our North Carolina facilities. And that's with North Carolina having a 9.9 ROE within their rate structure. So obviously there are a number of features within the rates that certainly need to be examined.
And it would go without saying, would it not, Mr. Chris, that where Walmart's costs lower, it could pass those cost savings on to its customers?
That's correct.
Thank you, sir. No further questions, Mr. Chairman.
Thank you. Nucor. Thank you. ORS. Thank you. Commissioners. Okay. Thank you. Mr. Chris, appreciate you being here, and you may step down and be excused. Thank you very much. Okay, Mr. Elliott.
Mr. O'Donnell, would you please state and spell your name for the record?
It's Kevin O'Donnell. Last name is spelled capital O apostrophe capital D-O-N-N-E-L-L.
Thank you. Are you the, by whom are you employed and what do you do, sir?
I'm president of Nova Energy Consultants.
Did you cause to be prepared and pre-filed in this testimony, in this docket, 48 pages of public direct testimony?
Yes.
And did you also cause to be prepared and pre-filed in this docket 48 pages of confidential testimony?
Yes.
Have you had a chance to review your pre-filed direct testimony prior to your appearance?
Yes, I have.
Do you have any corrections, changes, or additions to your pre-filed direct testimony?
No, I do not.
If I asked you those same questions today, would your answers be the same?
Yes.
Mr. Chair, I'd move the pre-filed direct, confidential, and public version into the record at this time as if given orally from the stand.
Mr. O'Donnell's pre-filed direct testimony, public and confidential, will be read into the record as though given orally from the stand.
Thank you, sir. And, Mr. Chairman, I realize this morning...
And the confidential will be held under seal.
Very fine. Thank you. I've noticed as I was preparing for my appearance today that my office failed to pre-file the appendix that was to be attached to Mr. O'Donnell's testimony. It's his resume. It is the same appendix as was found in his Duke testimony. I've consulted Duke counsel. He's very graciously allowed me to offer it into the record at this time. I provided the court reporter with a copy. So with that, I would move into the evidence the appendix to Mr. O'Donnell's testimony, please.
Okay, Mr. O'Donnell's appendix will be entered as exhibit number 51.
Thank you, sir. And Mr. O'Donnell, did you cause to be prepared and pre-filed 5 pages of surrebuttal in this docket?
Yes, I did.
Have you had a chance to read your surrebuttal testimony?
Yes, I have.
Do you have any changes or corrections to your surrebuttal?
I do not.
If I ask you those same questions today, would your answers be the same?
Yes.
Very fine. Move the surrebuttal testimony into the record, Mr. Chairman.
Mr. O'Donnell's surrebuttal pre-filed testimony will be entered into the record as though given orally from the stand.
Thank you very much, and thanks to counsel, too, for their cooperation. Mr. O'Donnell, have you prepared a summary of your direct and surrebuttal testimony?
Yes, I have.
Would you please present it at this time?
Yes. My testimony in this case reviewed 3 items in this case: Duke Energy Progress's cost to manufacturers in South Carolina, DEP's requested level of coal ash cost, and the company's real-time pricing rates. DEP's cost to manufacturers. The future of DEP's manufacturing load in South Carolina is cause for great concern. The company has lost a large amount of its industrial load since 2006 and is showing no sign of a rebound anytime soon. Given Duke's outspoken plans for massive grid investments to drive its own earnings, manufacturing in the northeast corner of South Carolina is being severely challenged. Coal ash cost. DEC spilled coal ash into the Dan River in February 2014. North Carolina passed the Coal Ash Management Act, CAMA, as a direct result of the Dan River spill in September 2014. In an attempt to show how the DEP coal ash costs compared to other utilities across the country, I provided a comparison of coal ash asset retirement obligations, which are accounting entries to recognize future liabilities. My analysis shows that Duke's coal ash liabilities are high in regard to the rest of the United States. I note that Duke did not perform any such comparative analysis. I further note that a recent ruling by the North Carolina Division of Environmental Quality may double the cost of the DEP and DEC coal ash cost in the future. Real-time pricing rates. I reviewed DEP's real-time pricing rates for 2018 and found these costs to be substantially higher than prices as found in the open competitive market. Duke operates a closed system for its retail electric service and does not offer large customers access to the competitive wholesale markets. My analysis indicates Duke should offer its large customers on its RTP rates the lower of open market cost or Duke's RTP rates. Doing so would not negatively impact any other rate class, will not negatively impact DEP, and could possibly stem the tide of rising manufacturing rates in the DEP service territory. Duke Energy Progress's response to date of my analysis is to claim their RTP rates were not designed to mimic market cost. Such a weak response does nothing to help manufacturers in its service territory. This completes my summary.
Thank you, Mr. O'Donnell. Mr. O'Donnell is available for questions or cross-examination. Thank you.
Thank you. Walmart. NAACP. Sierra Club. Nucor. ORS.
Good afternoon, Mr. O'Donnell. How are you?
I'm good. How are you doing?
Okay, good. Mr. O'Donnell, I'm going to start with some just general questions. You're here on behalf of the South Carolina Energy Users Committee, is that correct?
That's correct.
How many employees do the members of the South Carolina Energy Users Committee employ in South Carolina?
I don't know our committee how many we employ, but I do know there's about 250,000 South Carolinians working in the manufacturing sector.
Okay. Are electric costs a significant concern to the Energy User Committee members?
Absolutely. Every time we get together, we discuss how South Carolina compares to other parts of the country, and oftentimes it's not a pretty conversation.
Have you looked at the current economic conditions in the Progress South Carolina territory?
Yes, in preparing for this case, I did review unemployment data as well as wage data for the northeastern corner of South Carolina.
Can you give me information regarding, say, unemployment statistics in the Progress territory in South Carolina?
Yes, I can. Unemployment, nationally, it's 3.8%. And when you look through the various counties which I attempted to do in preparing for this case, it's quite a range of unemployment numbers in the northeast corner of the state. The highest, however, is Marlborough County at 8.6%. Dillon is 5.5%. Florence is a little bit below the national average at 3.4%, but Darlington is 3.9%. So overall, when you look at the grand scheme of it, it looks like unemployment is a little bit higher in the northeastern corner of South Carolina than it is relative to the national.
Do you have any data on wages?
I did look at that as well. The national weekly wage is $1,021. In South Carolina, it's $828 a week. In Florence County, it's $725. Dillon, $596. Sumter, $712. I mean, I can list all the counties here, but the bottom line is in the northeastern corner of the state, the weekly wages compared to both South Carolina and the national, they compare very poorly.
Thank you. Turning specifically to the large general service, the large general service classification, the company is requesting or proposing changing the base facilities charge from $98 to $195. That's roughly a 100% increase. Is that correct?
The math is about right, yes.
Okay. Can industrial customers, can they increase the price of their goods to accommodate that kind of increase in the basic facilities charge?
No, they're not. They're going to have to absorb that, and then due to market conditions, supply and demand, they may be able to move prices a little bit, but they're going to have to absorb that cost first, and then figure out how to pay for it later.
Thank you. I'm going to turn to coal ash. With regard, that is an area that you looked at as part of this case, correct, Mr.
Right.
O'Donnell?
Correct.
And were you active? And were you active in the case of North Carolina on coal ash?
Very, yes.
Mr. O'Donnell, it's ORS's position that the CAMA, the North Carolina Coal Ash Management Act, imposes requirements on DEP Progress that are in excess of those imposed by the federal CCR alone. Are you aware of ORS's position?
Yes, I am.
Okay. What's your opinion on that position?
When I first started doing this coal ash work in North Carolina a couple years ago, obviously, being a finance person, the first thing I did was do a financial ratio analysis, and the data indicated that the costs for Duke were substantially higher than other utilities. So that led me to conclude that CAMA was more stringent than the federal requirements, CCR. But then when I was doing this process, I noticed that Duke's Director of Environmental Policy, Mark McIntyre, stated publicly in an article on Utility Dive that's quoted in my testimony, where he says that from a comparison perspective, the CAMA is generally a good bit more stringent. So this is coming from a Duke employee, environmental policy. All he did there was basically confirm what my analysis had indicated.
Does a ruling by the North Carolina Utility Commission govern South Carolina?
No.
You would agree with me that a conclusion reached by the North Carolina Utility Commission is not binding on this commission?
That's correct.
Okay. Similarly, would you agree with me that laws passed by the North Carolina General Assembly are not binding on the citizens of South Carolina?
Mr. Chairman, asking this witness for legal opinion outside of his scope and also for conclusions that are self-evident.
I can rephrase. Mr. O'Donnell, has South Carolina's General Assembly adopted CAMA?
No.
Okay. And would, from a fairness perspective, not from a legal conclusion perspective, do you think it would be fundamentally unfair for laws passed in by the General Assembly in North Carolina to impose cost on the citizens of South Carolina?
Absolutely.
Okay. There's been some talk about benefication. What does the term benefication mean to you?
Well, I'll be honest with you. When I got here earlier today,
Mr. Chairman, objection. This witness is well beyond the scope of any of his pre-filed testimony, and this orchestrated friendly cross is at best duplicative.
Okay, he can answer this question.
I'll be honest, when I got here today and I heard that word, first thing I do is pull out my phone and look it up because I'd never heard it before. I think what it means is basically something happens in one area, everyone benefits the entire area, the entire two states. That is what I took from what I read on Google.
Under CAMA, will South Carolina customers actually save money?
Objection lacks foundation. And beyond the scope of testimony, no basis of evidentiary opinion in the record for this opinion for this witness.
May I briefly respond? Certainly, Mr. O'Donnell is here on behalf of the industrial customers, and I do believe he refers and takes issue with the coal ash costs. The company has asserted that there is a benefication, a savings. Certainly, Mr. O'Donnell would, after having reviewed the testimony in this case, could speak to that.
Okay, he can answer the question.
I'm sorry, can you repeat that, please?
Maybe not. Sorry. Under CAMA, okay. The allegation or the contention's been made that South Carolina customers are actually saving money. What is your reaction to that?
I don't understand how paying more means somehow you save. That is counterintuitive. I don't see how South Carolinians are going to save money by paying higher cost under CAMA than they would under the federal rule CCR.
Again, Mr. O'Donnell, you've been very active in North Carolina Utility Commission proceedings. Is that fair?
Yes.
Okay. And are you familiar with the piece of North Carolina legislation called House Bill 589?
Yes.
Okay. And is it your understanding that the industrial customers that you represent in North Carolina, that the costs for House Bill 589 are being passed to the North Carolina customers?
Objection, Mr. Chairman. We're now asking this witness questions about a North Carolina renewable energy bill.
Mr. Chairman, if I may briefly respond, the whole issue is when there's North Carolina laws that have been specifically the cost been passed on to North Carolina customers, as a representative of the industrials, Mr. O'Donnell would be have knowledge as to whether or not those costs are going to North Carolina customers, but are not similarly going to South Carolina customers. And just to advance it, I'm going to also ask him about South Carolina Act 236 on the same basis.
Mr. Chairman, briefly, witness Seaman Wynn, as I was instructed vehemently in the last EEC proceeding, is the policy expert that this organization has sponsored for this very issue. I would suggest that she put on her own witness rather than trying to elicit this through Mr. O'Donnell, who has not even remotely touched this in any of his pre-filed testimony.
Cross is open, and I'm not limited to his pre-filed direct.
Okay, I agree, that's true, but we're moving very far away from where we were, so let's get back to Mr. O'Donnell's testimony. And use, I think I agree that we need to use your witness.
Mr. Chairman, if I may, just as a clarification, can I factually ask him the question of whether or not he's aware that certain pieces of legislation cause costs for his client in certain states but not in others?
Sure, you can ask that, but let's keep it narrow.
Thank you, Mr. Chairman. Mr. O'Donnell, do you need me to repeat that question?
No, I got that one. No, I've never seen anything like that happen from one state to another. It's always confined in the state where the action takes place and the regulatory body sits.
All right. Are you aware of this newest North Carolina DEQ decision?
I have read only the press clippings on it, and I do know that it's going to basically double Duke's costs. And I have also read, as of this morning, that it looks like somehow Duke is going to appeal it. I don't know how they're going to do that, whether it's I just don't know how they're going to do it, but I understand they're not happy with it and plan to somehow appeal it.
If this commission...
Mr. Chairman, I'm sorry. ORS objected to Mr. Caron's supplemental testimony being filed on this record, and I believe there's a letter objection in the record stating that the DEQ order is irrelevant to this proceeding and thus should not be discussed. I withdrew Mr. Caron's testimony this morning based on that objection in conference with ORS. ORS has now opened the door to this and is asking questions. So if allowed, I would ask that Mr. Caron's testimony be entered back into the record.
I just wanted to know if he knew of the issue, but I can move on.
Let's move on.
All right. If this commission grants the company's request in this case for coal ash recovery and remediation, do you think industrial customers will be fearful of locating to South Carolina?
Yes, because it's not only going to raise the costs here in this state, but it's also going to set the precedent for future rate cases that would involve coal ash, meaning that whatever's decided in this case could further would further increase cost in the future for Duke Progress customers.
Okay. And the amount, just as to remind my recollection of the amount, and wanted to see if you recall, the amount that the company is seeking as an additional revenue requirement in this case for coal ash is $12.9 million annually. Is that Is that your recollection?
Annually, yes.
What is your position on the customers paying for DEP's litigation costs related to coal ash?
Very much opposed to it. I mean, if they can somehow tie it a normal cost of business, then I can certainly understand some form of that. But if it's not into your normal course of business because you did something related to a coal ash pond that maybe you shouldn't have, or then I'd obviously oppose anything like that.
I'm going to change topics at this point. Mr. O'Donnell, again, you've appeared before the Commission in North Carolina on rate cases associated with Duke and Progress. Is that correct?
Correct.
Okay. Compensation or bonuses. Are you aware that ORS recommended removal of approximately $4.1 million in bonuses in this case?
I'm aware of that.
Yeah. And based on your experience in other states, do you have an opinion as to whether or not ORS's recommendation that the bonuses be split 50-50 such that customers pay half and shareholders pay half? Do you have an opinion on that recommendation?
Honestly, I think what the ORS is recommending here is a little bit generous. I personally don't believe that bonuses should be paid for by consumers. I have no problem whatsoever with whatever stockholders do. I mean, that's why you have executive management of the utilities. Their primary goal is to drive earnings and increase the stock price. Well, you know, if they do that, then fine, give them a bonus out of stockholder money. I don't believe the consumers ought to pay that because these folks are already paid for their services. And I think bonuses need to stay in the realm of the stockholders entirely.
Are you aware that in addition to the bonuses that I just referenced, that there is an additional $116,530 for exceptional contribution awards that the company is including in non-labor O&M expenses?
I'm aware of that.
Okay. And just a moment, Mr. Chairman. Let me make sure I covered all my questions. Going back to, I missed one. Going back to the coal ash, is it your understanding that if the federal laws were changed, then if the federal laws were changed to include the CAMA requirements, would you understand that ORS's position would then be that if it's under the federal law, that it would have to be, the customers would have to pay it?
Objection. Vague, ambiguous, calls for a legal conclusion.
I could rephrase. Would you see that, would you have an opposition if, in fact, the federal laws were changed such that customers would then have to pay the higher cost associated with CAMA?
I've been consistent in what I've said, going back to the North Carolina case, that if CAMA equals CCR, customers are going to pay it. But to the extent there's any incremental cost difference, then I think stockholders need to pay it. So I think under that scenario you just raised, I think myself and the IRS would be in line.
Okay, thank you.
Thank you. Mr. Burnett.
Mr. Donald, when you were talking with counsel for ORS, I think we established you're here on behalf of the South Carolina Energy Users Committee, or SCEUC, correct?
That's correct.
Can you tell me which members of the SC, EUC, or Duke Energy Progress customers?
No, I can't. I don't know who they are. Mr. Elliott may know, but I do not.
Can you name any SC, EUC member that's a Progress Energy customer? Duke Energy Progress.
Well, can I ask my counsel whether or not I can disclose a name?
Well, Mr. O'Donnell, I found that list on the SCEUC website that I logged into publicly, so I don't understand that they're confidential unless I have hacking skills that I don't realize.
Well, I haven't been on that website in years, so you're one step ahead of me. I believe that Tally Metals is, well, I know they're a member of SCEUC, and they're in the Duke Progress territory. Tupperware, I believe. But I'm lost beyond that.
Mr. O'Donnell, did you not think it would be good to know who all the actual customers that you were hired to represent are before you came here to provide testimony on how certain elements of this case may impact them?
Well, you know, when I go to these meetings and what I hear them talking about consistently is their cost structure. And when you have a room full of industrial folks, I don't necessarily know from one to the other. So the quick answer to that is I have a general understanding that an increase in rates is not going to be good for them.
Mr. O'Donnell, in your direct testimony, you state if the cost to manufacture a particular product is less expensive in another state or country, the manufacturer has a duty to its customers and stockholders to move the manufacturing to the area of least cost. Isn't that correct?
That's correct.
And would you disagree with me that in the Duke Energy Carolinas proceeding that we just finished last month, you testified that when you talked to your manufacturing customers, they said, quote, "We're going to go where we have to get the lower power cost." Isn't that right?
That's right. That is consistent with what I hear from our members. They're going to locate where they can get the least cost power. And, you know, and specifically what I hear is if you have two plants that are identical between this state and Georgia, and they may look at the hourly pricing rates day ahead, and they see that the price in next state over is lower cost than here, they're going to idle a line. And you don't think about it from one day to the next. But when that happens consistently and the South Carolina employee goes home, that's significant. And so what I'm telling you is these are conversations that are going on right now. And what I'm hearing consistently is that Duke's costs are higher than what they're finding in other places of the country. And it's hurting the manufacturers in this in the Carolinas.
Mr. Chairman, I'd like to mark an exhibit for identification with the next hearing number, please. Hearing exhibit number, please.
Be number 52. What's that going to be? Are you going to show it to us?
Yes, sir. It's coming around now.
Okay.
Mr. O'Donnell, keeping Exhibit 52 handy so we could reference it if we need to, I want to ask you, can you name any Duke Energy Progress manufacturing customer that is planning on moving its South Carolina operations to another state? And if so, please tell me what state they are moving to.
No, because that would be, I would expect, highly confidential data that they're certainly not going to tell me, a consultant, when they're in the process of perhaps moving and laying off hundreds of people. So no, I cannot tell you that. I do not know of any at this particular point in time.
I see. So the testimony that you just provided, wherein you said that when you speak with these manufacturing customers, they express concerns and potentially moving to other states. Would it be fair to characterize that as hyperbole and you don't have any factual information on anyone who's actually planning to move anywhere?
Well, let me say this. You're welcome to come to any of our meetings and speak to our members anytime you would like to and hear the same kind of conversations I'm hearing. It's not hyperbole when you pick up a plant, you shut down the line and send it over to Georgia because their real-time pricing rates are lower than what you can get in the Carolinas. All I can do is tell you what I'm hearing from our members, and I know that your fellow Duke employees have come to these meetings that SC EUC has, and you've heard the same thing.
Mr. O'Donnell, you admit, do you not, that the price of electricity certainly is not the only consideration an industrial customer looks at when it decides to enter or leave a state to conduct business. Isn't that correct?
Well, that's absolutely correct, and I think I state that in my testimony. But when you have a energy-intensive industry, gas separation is one that comes to mind. Steel with electric arc furnaces. Oh, they look at that pretty heavily. And I know, for example, when you've got states that are deregulated, say, for example, Texas, where you can get energy cost 3.5 cents a kilowatt hour, folks are going to locate in areas like that as opposed to the fully regulated states where the rates are going up as opposed to going down in the deregulated states.
And Mr. Donald, even if we assume that the price for electricity were the only consideration as to where manufacturers locate and keep their operations, you will admit, will you not, that industrial electric rates in DE Progress's South Carolina territory have been and are still lower than national rates and mostly equal to or lower than the Southeast rates. Isn't that right?
And there's a graph in my testimony showing that. But there's also a graph in my testimony showing that you're losing a tremendous amount of load, and I don't see that load coming back anytime soon, particularly when you're not trying to do something innovative like your real-time pricing rates. In this graph that you provided here, yeah, what you just stated is an accurate statement, but it doesn't talk about the problems you have with your real-time pricing rates, and that is why I hear a lot of my folks talking about closing down a line and moving it across the border.
Well, I'd like to talk to you about that real-time pricing rate. You have you mentioned today a couple times, and you also mentioned in your direct testimony that some plants in South Carolina that produce a product that's identical to a sister plant in Georgia will look at the day-ahead pricing for electricity, determine a real-time pricing rate, and if it's higher in South Carolina, they'll close that South Carolina operation in favor of Georgia. Isn't that right?
Yes.
And further speaking about the company's real-time pricing rates, you state on page 5, lines 9 through 14 of your rebuttal testimony that the company has shown, quote, a level of indifference to the competitive nature of its real-time pricing rate. Isn't that correct?
That's correct.
But you will agree with me, will you not, Mr. O'Donnell, that the real-time pricing rate for Duke Energy Progress customers is heavily discounted as an incentive to bring customers to that rate and incent them to alter their electric usage behavior?
Heavily discounted to what?
Well, if I, Mr. Chairman, if I could get the next hearing exhibit, please, Nora.
Next number will be 53.
Thank you, sir. Mr. O'Donnell, I'm handing a document out that is marked for identification as exhibit number 53. I'll wait till you get a copy of it. Mr. O'Donnell, the document that I'm showing you that has been marked as exhibit 53 is an actual customer application to be on the Duke Energy Progress real-time pricing rate that I've redacted to eliminate the customer's name and facility information. Have you ever seen a document like this before?
Several years ago.
And if you will please turn to the second page of Exhibit 53 and turn your attention to paragraph 11B as in Bravo, do you see there where the billing demand to determine the customer's monthly base charge is reduced by 30.571%?
On the billing demand on this regulated rate, that's true. I'm sorry. I thought you were talking about discount relative to market rates, but I see your point here relative to regulated rates.
So when you testify in your sir rebuttal testimony that Duke Energy Progress has shown a level of indifference to the competitive nature of its real-time pricing rate, you fail to mention to the Commission that customers on that rate are already receiving an almost 31% reduction in their monthly billing demand. Isn't that right?
Well, you brought up a point here, and that's a fair point, but what I'm trying to say is relative to open market costs, and I pointed this out in my testimony, and in the response I got from the company's testimony was, well, our rates aren't designed that way. That is a level of indifference to me, because when you are having your customers say, we want something more, and the response from the company is, well, that's just not how we do business, that is a level of indifference to me. And I'm telling you that relative to your real-time pricing rates, relative to the market cost, are higher. And I fail to understand why why we're even arguing this point, because what we're trying to do here is keep y'all whole, help the customer, help the economy, not hurt any other customer class. Why is this difficult? Instead of running your CT plant, your gas CT, that may be 20 years old, why not buy it on the open market and pass that real-time pricing savings on to customers? It doesn't negatively impact Duke Progress. It doesn't hurt other customers. Customer benefits. And the only response I've got is that, well, that's not how we do business. To me, that's a level of indifference.
Mr. O'Donnell, staying on the topic of things that an industrial or manufacturing customer might consider to move into the state of South Carolina or to leave it, you would agree with me, would you not, that industrial customers like the one you represent enjoy the ability to opt out of participating in the energy efficiency and demand side management rider in South Carolina? Isn't that true?
That's true.
Mr. Chairman, I'd like to have one last exhibit marked with the next exhibit number, please. I believe it's 53.
The next will be 54.
Oh, 54. Mr. O'Donnell, what I've shown you is a graph that purports to show the percentage of cost that the DSM and EE rider puts on an industrial, well, several customers' bills, including large industrials. And if I could draw your attention to the left-hand side of Exhibit 54, where it says large commercial industrials, you would agree with me, would you not, that if the information on this graph is correct, the ability to opt out of the DSM and EE rider in South Carolina can save customers that you represent about 7.73% off their electric bill if they choose to opt out?
I would agree that's what the chart says, but I think you need to understand why the customers have the ability to begin with, because we're in a competitive environment and we've been doing energy efficiency for years, decades. That's how we stay competitive. So there is a little bit of method in the madness as to why the General Assembly allowed industrials to opt out of this.
Well, Mr. Donald, that's not true at all in South Carolina, is it? Because the General Assembly here has not allowed this opt-out. Rather, that is a product of Commission order, specifically PSC Order 2015-596 in docket 205163E, dated August 19, 2015, page 9, paragraph G. Isn't that right?
That was a mouthful, and I'll accept what you said, and I congratulate the Commission for doing that, because industrials should be opted out given everything that they have done and continue to do for EE in this state. I mean, it's a matter of survival for them. You have to be very cognizant of all of your costs, and they are. So I think there was, whether the General Assembly allowed for the opt-out or whether this commission allowed for the opt-out, either way that the opt-out is in there, and it's a good thing.
That's right, Mr. O'Donnell. And you would certainly agree then that if I'm an industrial customer and I'm going to move to a state, for instance, that may have presumptively cheaper rates on their face, but let's say they have mandatory participation in DSM and EE, like Florida, for instance, you'd have to consider that before you make a bold move to another state. Isn't that right?
Oh, absolutely. You're absolutely right. You're going to look at the whole ball of wax. You're going to be looking at everything.
And on that note, before a customer makes a move from South Carolina to another state, it would also have to consider cost allocation methodologies that some of these other competing states use to make a fulsome determination. Isn't that right?
No. No. At the end of the day, customers only care about what are your costs. We here, I mean, we're in the process of making the hamburger. That's not, when a manufacturer is looking at it, they're just going to look at the final product. How they get to that final product, they really don't care. That's just reality. It's kind of like when I'm doing wholesale work right now in the competitive wholesale market. I'm looking at the bottom line. I'm looking at the credit background of the company that I may be buying the power from, and I'm looking at the bottom line. I'm not looking at cost allocation. That's beyond the scope of what I was hired to do. And with the manufacturer, they're not looking into the details of how a rate was developed. They're looking at what that rate is.
Mr. O'Donnell, if I understand your testimony, then if the industrial customers you represent don't care about cost allocations, then you would have no issue then with me proposing to this commission perhaps next month that rather than using a single summer coincident peak for cost allocation, that this commission moved to, let's say, a 12 CP and 50% average demand methodology like other states use. Would that be accurate?
I think what you've done is, I'm afraid you misunderstand what I'm trying to say. Those allocations end up in the final product. That final product is what customers care about. But if you go out and talk to my manufacturers right today, they may not know the difference between a Quinston peak rate and a non-Quinston peak rate. All they know that they're paying 7 cents a kilowatt hour, and that's high relative to other states that they're paying. So, yeah, they do care about how you get to that point. But at the end of the day, they're going to make a decision based upon where that point is. And if South Carolina's rates are climbing because of grid mod, for example, that's going to play a pretty big impact on where they end up locating.
I appreciate your time today, sir.
Thank you. Mr. Elliott, any redirect? No, hang on, commissioners. Commissioner Whitfield.
Thank you, Mr. Chairman. Mr. O'Donnell, on page 44 of your pre-filed direct testimony, you recommend a 75% disallowance of the company's request for coal ash disposal costs. How did you settle on the 75%?
It was based on that ARO analysis I did and looking at what the other states have and looking at the national average cost that I came up with, and then saying, well, it appears to be that North Carolina's and South Carolina's costs are about 3 times higher than the rest of the average in the country. So that's basically how I came up with it. It was based upon that ARO analysis.
Okay, so it was on the ARO analysis, and it wasn't on the assets in North Carolina that any kind of breakdown of that, sharing it between DEP ratepayers in North Carolina and DEP ratepayers in South Carolina. It wasn't that.
No, sir. It was just based on a strict financial analysis of the ARO numbers.
All right. Well, thank you, sir. That's all I have, Mr. Chairman.
Commissioners, other questions? Okay. Mr. Burnett, I want to make sure we mark 52, 53, and 54. Do we want to enter those?
Yes, sir. May I please move all three of those into evidence?
We'll enter those three into evidence. Okay. Now, Mr. Elliott.
Mr. O'Donnell, understanding it's 4:30.
Yes, sir.
It seems I'm always the fortunate one to be standing here at 4:30 with questions. Would you please, you were asked a number of questions by counsel about real-time pricing. Could you explain in just a little bit of detail what real-time pricing is?
Yes, so real-time pricing is rates that are offered up to industrial customers basically every hour for the next 24 hours. So, for example, Duke may send an email or some kind of notification out to customers at some point in the previous day and say, hey, tomorrow your RTP rates are going to go from 1.5 cents up to 3 cents a kilowatt hour on the energy side only. And the customer then has to decide, okay, well, do I want to operate during the hours of between 3 o'clock and 6 o'clock in the afternoon when the prices are going to be really high? So they are costs that will vary by hour that are obviously set so that customers will have some kind of incentive to adjust their manufacturing load.
And do all utilities, electric utilities, offer some sort of real-time pricing tariff?
Not all. You get the smaller utilities, particularly the ones I work with, municipalities. No, they don't. Most of the large investor-owned utilities do offer that for those in the regulated states. Now, the states that are deregulated, no, that you've already got markets set up, and they, as we saw in my testimony, those rates are very attractive, and customers can buy on an hourly basis.
And for instance, is Georgia a regulated state?
Yes.
Is North Carolina a regulated state?
Yes.
What's the advantage to an industrial customer to take service on a real-time pricing tariff?
It does overall save customers money, but what I've heard recently from our members is that the real-time pricing rates for Duke have gone well above market. And I think my analysis indicates exactly that. But relative to the standard Duke rate, real-time pricing rate can save you money.
So if we look at Exhibit 52, which is the map of the Southeast, first of all, I would ask you, is it your understanding that this is the average industrial revenue comparison as opposed to a real-time pricing comparison?
Yeah, these are EEI typical bills. I don't believe these have RTP values to them. If they were EIA numbers, then they would have RTP values to them. But these are EEI typical bills. This is an apples to orange comparison as far as I can tell.
And your testimony in your direct and supplemental testimony is pertains to the way Duke sets its cost for real-time pricing, correct?
Correct.
And as I understand your testimony, what you're proposing is a way for Duke to reduce its real-time pricing tariff without affecting Duke's bottom line, correct?
That plus not impacting other customers. That's correct.
All right. I don't have any further questions. Thank you, Mr. Chairman.
Thank you, Mr. Elliott. Any recross? Okay, Mr. O'Donnell, we appreciate you being here. Thank you for your testimony, and you may step down and be excused.
Thanks, sir.
Okay. So we come to the end of today, and we will start again tomorrow morning at 10 a.m. We are adjourned.